Special groups of employees. Women. Discrimination. Q. An airline which flies both the international and domestic routes requested the Secretary of Labor and Employment to approve the policy that all female flight attendants upon reaching age 40 with at least 15 years of service shall be compulsorily retired. However, flight attendants who have reached age 40 but have not worked for 15 years will be allowed to continue working in order to qualify for retirement benefits. But in no case will the extension exceed 4 years. Does the Secretary of Labor and Employment have the authority to approve the policy? Yes. The Secretary of Labor and Employment has the authority to approve a policy dealing with the retirement of flight attendants of airlines. Article 132, letter D of the Labor Code provides that the Secretary of Labor and Employment shall establish standards that will ensure the safety and health of women employees, including the authority to determine appropriate minimum age and other standards for retirement or termination in special occupations, such as those of flight attendants and the like. Caveat: it could be argued that Article 132, letter D, may be unconstitutional because this may constitute discrimination in violation of the spirit of Section 14 of Article 14 of the Constitution, which provides that the state shall protect working women by providing safe and healthful working conditions, taking into account their maternal functions, and such facilities and opportunities that will enhance their welfare and enable them to realize their full potential in the service of the nation. Q. An exclusive school for girls run by a religious order has a policy of not employing unwed mothers, women with live-in partners, and lesbians. Is the policy violative of any provisions of the Labor Code on employment of women? No, the policy does not violate the Labor Code. The practice is a valid exercise of management function. Considering the nature and reason for existence of the school, it may adopt such policy as will advance its laudable objectives. In fact, the policy accords with the constitutional precept of inculcating ethical and moral values in schools. The school policy does not discriminate against women solely on account of sex. Article 135, Labor Code, nor are the acts prohibited under Article 137 of the Labor Code. The same school dismissed 2 female faculty members on account of pregnancy out of wedlock. Did the school violate any provision of the Labor Code on employment of women? No, because to tolerate pregnancy out of wedlock will be a blatant contradiction of the school's laudable mission, which, as already stated, accords with high constitutional precepts. This answer does not contradict the ruling in Chua Kua, where the teacher merely fell in love with a bachelor student and the teacher, also single, did not get pregnant out of wedlock. Stipulation against marriage. Phil-Air Aviation Company is a new airline company recruiting flight attendants for its domestic flights. It requires that the applicant be single, not more than 24 years old, attractive, and familiar with 3 major Visayan dialects: the Ilonggo, Cebuano, and Waray. Lourdes, 23 years old, was accepted as she possessed all the qualifications. After passing the probationary period, Lourdes disclosed that she got married when she was 18 years old, but the marriage was already in the process of being annulled on the ground that her husband was afflicted with a sexually transmissible disease at the time of the celebration of their marriage. As a result of this revelation, Lourdes was not hired as a regular flight attendant. Consequently, she filed a complaint against Phil-Air, alleging that the pre-employment qualifications violate relevant provisions of the Labor Code and are against public policy. Is the contention of Lourdes tenable? The contention of Lourdes is tenable. When she was not hired as a regular flight attendant by Phil-Air because she disclosed that she got married when she was 18 years old, the airline company violated the provision of the Labor Code which states, "It shall be unlawful for an employer to require as a condition of employment or continuation of employment that a woman employee shall not get married, or to stipulate expressly or tacitly that upon getting married, a woman employee shall be deemed resigned or separated, or to actually dismiss, discharge, discriminate, or otherwise prejudice a woman employee merely by reason of her marriage. Q. Mam Manu Aviation Company. Mam Manu is a new airline company recruiting flight attendants for its domestic flights. It requires that the applicant be single, not more than 24 years old, attractive, and familiar with 3 dialects, Ilonggo, Cebuano, and Kapampangan. Inga, 23 years old, was accepted and she possesses all the qualifications. After passing the probationary period, Inga disclosed that she got married when she was 18 years old, but the marriage was already in the process of being annulled on the ground that her husband was afflicted with sexually transmissible disease at the time of the celebration of their marriage. As a result of this revelation, Inga was not hired as a regular flight attendant. Consequently, she filed a complaint against Man Manu alleging that the pre-employment qualifications violate relevant provisions of the Labor Code and are against public policy. Is the contention of Inga tenable? Why? 2012. Yes, Man Manu's pre-employment requirement cannot be justified as a bona fide occupational qualification, where the particular requirements of the job would justify it. The said requirement is not valid because it does not reflect an inherent quality that is reasonably necessary for a satisfactory job performance. PT&T and versus NLRC. Sexual harassment. Q. As a condition for her employment, Josephine signed an agreement with her employer that she will not get married, otherwise she will be considered resigned or separate from the service. Josephine got married. She asked Owen, the personnel manager, if the company can reconsider the agreement. He told Josephine he can do something about it, insinuating some sexual favors. She complained to higher authorities, but to no avail. She hires you as her counsel. What action or actions will you take? As counsel for Josephine, I will file a complaint for work-related sexual harassment, which, as in the case of Barr, occurs when a person who has authority, influence, or moral ascendancy over another demands, requests, or otherwise requires any sexual favor from the latter as a condition for, inter alia, the continued employment of said individual. Section 3 RA 7877. I will likewise file a complaint for illegal dismissal, citing Article 136 of the Labor Code, which provides that it is unlawful for an employer to require, as a condition for continued employment or continuation of employment, that a woman employee shall not get married, or to stipulate expressly or tacitly that upon getting married a woman employee shall be deemed resigned or separated, or to actually dismiss, discharge, discriminate, or otherwise prejudice a woman employee merely by reason of her marriage. Q. Pedrito Mascolado, a college graduate from the province, tried his luck in the city and landed a job as utility or maintenance man at the warehouse of a big shopping mall. After working as a casual employee for 6 months, he signed a contract for probationary employment for 6 months. Being well built and physically attractive, his supervisor, Mr. Hercules Barak, took special interest to befriend him. When his probationary period was about to expire, he was surprised when one afternoon, after working hours, Mr. Barak followed him to the man's comfort room. After seeing that no one else was around, Mr. Barak placed his arm over Pedrito's shoulders and softly said, "You have great potential to become regular employee, and I think I can give you a favorable recommendation. Can you come over to my condo unit on Saturday evening so we can have a little drink? I'm alone and I'm sure you want to stay longer with the company." Is Mr. Barak liable for sexual harassment committed in a work-related or employment environment? Yes. All the elements are present. A. The act of Mr. Barak was committed in a workplace. B. Mr. Barak, as supervisor of Pedro Mascolado, has authority, influence, and moral ascendancy over masculado. C. Given the specific circumstances mentioned in the question, like Mr. Barak following masculado to the comfort room, or Mr. Barak was requesting a sexual favor from masculado for a favorable recommendation regarding the latter's employment. D. It is not impossible for a male who is a homosexual to ask for a sexual favor from another male. Q. Can an individual, the sole proprietor of a business enterprise, be said to have violated the Anti-Sexual Harassment Act of 1995 if he clearly discriminates against women in the adoption of policy standards for employment and promotions in the enterprise? When an employer discriminates against women in the adoption of policy standards for employment and promotion in his enterprise, he is not guilty of sexual harassment. Instead, the employer is guilty of discrimination against women employees, which is declared to be unlawful by the Labor Code. For an employer to commit sexual harassment, he, as a person of authority, influence, or moral ascendancy, should have demanded, requested, or otherwise required a sexual favor from his employee, whether the demand, request, or requirement submission is accepted by the object of said act. In the question, no such act was committed by the sole proprietor. Q. Attorney Renan, a CPA lawyer and managing partner of an accounting firm, conducted the orientation seminar for newly hired employees of the firm. Among them was Miss Maganda. After the seminar, Renan requested Maganda to stay, purportedly to discuss some work assignment. Left alone in the training room, Renan asked Maganda to go out with him for dinner and ballroom dancing. Thereafter, he persuaded her to accompany him to the mountain highway in Antipolo for sightseeing. During all days, Renan told Maganda that most, if not all, of the lady supervisors in the firm are where they are now, in very productive and lucrative posts, because of his favorable endorsement. Did Renan commit acts of sexual harassment in a work-related or employment environment? Yes. Attorney Renan is guilty of sexual harassment. This conclusion is predicated among the following consideration. A. Attorney Renan has authority, influence, or moral ascendancy over Ms. Maganda. B. While the law calls for a demand, request, or requirement of a sexual favor, it is not necessary that the demand, request, or requirement of sexual favor be articulated in a categorical oral or written statement. It may be discerned with equal certitude from the acts of the offender. Domingo versus Royala. C. The acts of Attorney Renan towards Ms. Maganda resound with defining clarity the unspoken request for a sexual favor, regardless of whether it is accepted or not by Ms. Maganda. D. In sexual harassment, it is not essential that the demand, request, or requirement be made as a condition for continued employment or promotion to a higher position. It is enough that Attorney Renan's act results in creating an intimidating, hostile, or offensive environment for Ms. Maganda. Q. Determine whether the following minors should be prohibited from being hired and from performing their respective duties indicated hereunder. A. A 17-year-old boy working as a miner at the Walwaldi Mining Corporation. Yes, he should be prohibited from being hired and from performing the duties of a miner, because such constitutes hazardous work under DO 04, Series of 1999, Article 139, Letter C of the Labor Code, expressly prohibits the employment of persons below 18 years old in an undertaking which is hazardous or deleterious in nature as determined by the Secretary of Labor. B. An 11-year-old boy, he is an accomplished singer and performer in different parts of the country. No, he should not be prohibited from being hired and from performing as a singer. Under Article 8, Section 12, Paragraph 2 of RA 7610 as amended by RA 7658, this constitutes an exception to the general prohibition against the employment of children below 15 years of age, provided that the following requirements are strictly complied with A. The employer shall ensure the protection, health, safety, and morals of the child. B. The employer shall institute measures to prevent the child's exploitation or discrimination, taking into account the system and level of remuneration and the duration and arrangement of working time. And C. The employer shall formulate and implement, subject to the approval and supervision of competent authorities, a continuing program for training and skill acquisition of the child. Moreover, the child must be directly under the sole responsibility of his parents or guardian, and his employment should not in any way interfere with his schooling. C. A 15-year-old girl working as a library assistant in a girls' high school. No, she should not be prohibited from working as a library assistant because the prohibition in the Labor Code against employment of persons below 18 years of age merely pertains to employment in an undertaking which is hazardous or deleterious in nature as identified in the guidelines issued by the Dole Secretary. Working as a library assistant is not one of the undertakings identified to be hazardous under DO 04 series of 1999. D. A 16-year-old girl working as a model promoting alcoholic beverages. She should be prohibited from working as a model promoting alcoholic beverages. RA 7610 categorically prohibits the employment of child models in all commercials or advertisements promoting alcoholic beverages and intoxicating drinks, among other things. E. A 17-year-old boy working as dealer in a casino. Yes, he should be prohibited from working as a dealer in a casino because Article 140 of the Labor Code prohibits the employment of persons below 18 years old in an undertaking which is hazardous or deleterious in nature as identified in the guidelines issued by the Dole Secretary. Working as a dealer in a casino is classified as hazardous under DO number 4, series of 1999, as it exposes children to physical, psychological, or sexual abuses. Q. You were asked by 3 paint manufacturing company regarding the possible employment as a mixer of a person aged 17 who shall be directly under the care of the section supervisor. What advice would you give? I will advise the paint manufacturing company that it cannot hire a person who is aged 17. Article 139, letter C of the Labor Code provides that a person below 18 years of age shall not be allowed to work in an undertaking which is hazardous or deleterious in nature, as determined by the Secretary of Labor. Paint manufacturing has been classified by the Secretary of Labor as a hazardous work. Kasambahay, 2015. Q. Soledad, a widowed schoolteacher, takes under her wing one of her students, Kiko, 13 years old, who was abandoned by his parents and has to do odd jobs in order to study. She allows Kiko to live in her house, provides him with clean clothes, food, and a daily allowance of 200 pesos. In exchange, Kiko does routine housework consisting of cleaning the house and doing errands for Soledad. One day, a representative of the Dole and the DSWD came to Soledad's house and charged her with violating the law that prohibits work by minors. Soledad objects and offers as a defense that she was not requiring Kiko to work, as the chores were not hazardous. Further, she did not give him chores regularly but only intermittently, as the need may arise. Is Soledad's defense meritorious? Soledad's defense is meritorious. Section 4, letter D of the Kasambahay Law, RA 10361, provides that the term domestic worker shall not include children who are under foster family arrangement and are provided access to education and give an allowance incidental to education, baon, transportation, school projects, and school activities. Linda was employed by Secretarian University SU to cook for the members of a religious order who teach and live inside the campus. While performing her assigned task, Linda accidentally burned herself. Because of the extent of her injuries, She went on medical leave. Meanwhile, SU engaged a replacement cook. Linda filed a complaint for legal dismissal, but her employer SU contended that Linda was not a regular employee but a domestic house help. Decide 2014. The employer's argument that Linda was not a regular employee has no merit. The definition of domestic servant or house helper contemplates one who is employed in the employer's home to minister exclusively to the personal comfort and enjoyment of the employer's family. The Supreme Court already held that the mere fact that the house helper is working in relation to or in connection with its business warrants the conclusion that such house helper or domestic servant is and should be considered as a regular employee. Apex Mining Corporation versus NLRC. Here, Linda was hired not to minister to the personal comfort and enjoyment of her employer's family, but to attend to other employees who teach and live inside the campus. Q. The weekly work schedule of a driver is as follows. Monday, Wednesday, Friday, drive the family car to bring and fetch the children to and from school. Tuesday, Thursday, Saturday, drive the family van to fetch merchandise from suppliers and deliver the same to a boutique in a mall owned by the family. Is the driver a house helper? The driver is a house helper. A person is a house helper or is engaged in domestic or household service if he or she renders services in the employer's home, which are usually necessary or desirable for the maintenance and enjoyment thereof, and including ministering to the personal comfort and convenience of the members of the employer's household, including the services of family drivers. A family driver who drives the family van to fetch merchandise from suppliers and delivers the same to a boutique in a mall owned by the family for whom he works should be paid the minimum daily wage of a driver in a commercial establishment. The Labor Code in Article 143 provides that no house helper shall be assigned to work in a commercial, industrial, or agricultural enterprise at a wage or salary rate lower than that provided by law for agricultural or non-agricultural workers. Home workers. Distinguish briefly but clearly a house helper from a home worker. Article 141 Domestic helper. One who performs services in the employer's house which is usually necessary or desirable for the maintenance and enjoyment thereof, and includes ministering to the personal comfort and convenience of the members of the employer's household, including the services of a family driver. Article 153 Home worker is an industrial worker who works in his or her home processing raw materials into finished products for an employer. It is a decentralized form of production with very limited supervision or regulation of methods of work. Q. Nova Banking Corporation is a rest house and recreational facility in the highland of Tagaytay City for the use of its top executive and corporate clients. The rest house staff includes a caretaker, 2 cooks, a laundry woman. All of them are reported to the Social Security system as domestic or household employees of the rent house and recreational facility and not of the bank. Can the bank legally consider the caretaker, cook, and laundry woman as domestic employees of the rest house and not of the bank? No, they are not domestic employees. They are bank employees because the rest house and recreational facility are business facilities as they are for use of the top executive and clients of the banks. Article 141 Labor Code, Apex Mining versus NLRC. Mrs. Josie Juan is the confidential secretary of chairman of the board of the bank. She's presently on maternity leave, in an arrangement where the chairman of the board can still have access to her services. The bank allows her to work in her residence during her leave. For this purpose, the bank installed a fax machine in her residence and gave her a cell phone and a beeper. Is Mrs. Juan a home worker under the law? No, she is actually an office worker. She is not an industrial home worker who accepts work to be fabricated or processed at home for a contractor, which work when finished, will be returned to or repurchased by said contractor. Article 155, Labor Code. Post-employment. Employer-employee relationship. Test to determine employer-employee relationship. Don Luis, a widower, lived alone in a house with a large garden. One day, he noticed that the plants in his garden needed trimming. He remembered that Lando, a 17-year-old out-of-school youth, had contacted him in church the other day looking for work. He contacted Lando, who immediately attended to Don Luis' garden and finished the job in 3 days. Is there an employer-employee relationship between Don Luis and Lando? 2014. All the elements of employer-employee relationship are present. The selection and engagement of the employee, the power of dismissal, the payment of the wages, and the power to control the employee's conduct. There was also no showing that Lando has his own tools or equipment so as to qualify him as an independent contractor. Q. Pandoy, an electronics technician, worked within the premises of Perfect Triangle, an auto accessories shop. He filed a complaint for illegal dismissal of overtime pay and other benefits against Perfect Triangle, which refused to pay his claims on the ground that Pandoy was not its employee, but was an independent contractor. It was common practice for shops like Perfect Triangle to collect the services fees for customers and pay the same to the independent contractors at the end of each week. The auto shop explained that Pandoy was like a partner who worked within its premises using parts provided by the shop, but otherwise Pandoy was free to render service in the other auto shops. On the other hand, Pandoy insisted that he still was entitled to the benefits because he was loyal to Perfect Triangle. It being a fact that he did not perform work for anyone else. Is Pandoy correct? Pandoy is not correct. He is not an employee because he does not meet the fourfold test for him to be an employee of Perfect Triangle. All that he could claim is he worked within the premises of Perfect Triangle. Pandoy was not engaged as an employee by Perfect Triangle. He was not paid wages by Perfect Triangle. Perfect Triangle does not have the power to dismiss him, although the Perfect Triangle may not continue to allow him to work within its premises. And most importantly, Pandoy was not under the control of Perfect Triangle as regards the work he performs for customers. Malin Barton is a well-known radio and talk show host. She signed a contract with XYZ Entertainment Network to host a 1-hour daily talk show where she interviews various celebrities on topical subjects that she herself selects. She was paid a monthly remuneration of $300,000. The program had been airing for almost 2 years when sponsors' advertising revenues dwindled, constraining the network to cancel the show upon the expiration of its latest contract with Ms. Vartan. The talk show host protested the discontinuance of her monthly talent fee, claiming that it was tantamount to her illegal dismissal from the network since she has already obtained the status of a regular employee. As the network's legal counsel, how would you justify its decision to cancel Ms. Vartan's program, which in effect terminated her services in the process? As the network's legal counsel, I will argue that no employer-employee relationship exists between the network and Ms. Vartan. Reference has to be made to the terms and conditions provided under the contract, and the parties shall be governed by the provisions of the new Civil Code. In the case of J. Sonsa versus ABS-CBN, it was held that a TN and a radio talent is not an employee of the network company. Similarly, in this case, Ms. Vartan cannot be considered an employee of the network. Under the control test, the network had no control of the manner and means through which Ms. Vartan will perform her work. She herself selects the topical subjects in her interviews. She is also paid an extraordinary huge amount of $300,000 for her to be considered a mere employee. As counsel for the talk show hosts, how would you argue your case? As counsel for Ms. Vartan, I will argue that an employer relationship exists, and that she is a regular employee of the network because of the nature of her work in relation to the nature of the business of the network. Her work is usually necessary or desirable in the usual trade or business of the employer. Article 280 Labor Code. I will invoke the fourfold test of employer-employee relationship. Example: 1. Selection and engagement of employee. 2. Payment of wages. 3. Power to dismiss. And 4. Power of control. Q. Gregorio was hired as an insurance underwriter by the Guaranteed Insurance Corporation. He does not receive any salary but solely relies on commission earned for every insurance policy approved by the company. He hires and pays his own secretary, but is provided free office space in the office of the company. He is, however, required to meet a monthly quota of 20 insurance policies. Otherwise, he may be terminated. He was made to agree to a code of conduct for underwriters and is supervised by a unit manager. Is Gregorio an employee of Guaranteed? No. Gregorio is not an employee of Guaranteed. Control is the most important element of employer-employee relationship, which refers to the means and methods by which the result is to be accomplished. Avelino Lambo and Vicente Belocura versus NLRC. The requirement of complying with CODA, Company Code of Conduct, and supervision by unit managers do not go into means and methods by which Gregorio must achieve his work. He has full discretion on how to meet his quota requirement. Hence, there is no employer-employee relationship between Gregorio and Guaranteed. Alternative answer: yes, Gregorio is Guaranteed's employee. The fact that Gregorio was made to agree to a code of conduct and was supervised by unit manager are indicators that he is an employee of Guaranteed by using the control test mentioned in the Makati Haberdashery case. Furthermore, the fact that he was given a quota and can be terminated if he does not meet it all, the more indicated that he is indeed an employee of Guaranteed. In Angelina Francisco versus NLRC, the court added another element to a certain employer-employee relationship. This is whether or not the worker is dependent on the alleged employer for his continued employment. This was dubbed as the economic dependence test. The fact that Guaranteed can terminate Gregorio if does not meet the quota of 20 insurance policies a month mean that the latter is economically dependent on the former, which negates his status as an independent contractor and proves that he is an employee. Suppose Gregorio is appointed as unit manager and assigned to supervise several underwriters. He holds office in the company premises, receives an overriding commission and the commissions of his underwriters, as well as a monthly allowance from the company, and is supervised by a branch manager. He is governed by the Code of Conduct for unit managers. Is he an employee of Guaranteed? Yes, Gregorio is an employee. In fact, he is deemed as a regular employee. As a unit manager who was tasked to supervise underwriters, he can be said to be doing a task which is necessary and desirable to the usual business of Guaranteed. Article 295 of the Labor Code provides that the provisions of written agreement to the contrary, notwithstanding and regardless of the oral agreement of the parties, unemployment shall be deemed to be regular where the employee has been engaged to perform activities which are usually necessary or desirable in the usual business or trade of the employer. Alternative answer: yes. Article 291, letter M of the Labor Code defines a managerial employee as one who is vested with the powers or prerogatives to lay down and execute management policies and or to hire, transfer, suspend, lay off, recall, discharge, assign, or discipline employees. As Gregorio was appointed unit manager, the means and methods of accomplishing his goal come under the guideline laid down by the Guaranteed. Another alternative answer: no, Guaranteed did not define the duties and responsibilities of Gregorio. Guaranteed left it to Gregorio's discretion as to how he will achieve his goal. Therefore, the only interest Guaranteed has is in the result of Gregorio's work. Q. Matibay Shoe and Repair Store, as added service to its customers, devoted a portion of its store to a Shoeshine stand. The Shoeshine boys were tested for their skill before being allowed to work and given ID cards. They were told to be present from the opening of the store up to closing time and were required to follow the company rules on cleanliness and decorum. They bought their own Shoeshine boxes, polish, and rugs. The boys were paid by their customers for their services, but the payment is coursed through the store's cashier, who pays them before closing time. They were not supervised in their work by any managerial employee of the store, but for a valid complaint by a customer or for violation of any company rule, they can be refused admission to the store. Were the boys employees of the store? 2016, yes. The elements to determine the existence of an employment relationship are A. The selection and engagement of the employee. B. The payment of wages. C. The employer's power to control the employee's conduct. And D. The power of dismissal. The first element is present as Matibay Shoe allowed Shoeshine boys in its Shoeshine stand to render services that are desirable in the line of business of Matibay Shoe. In issuing IDs to the Shoeshine boys, the same signifies that they can represent themselves as part of the workforce of Matibay Shoe. The second element is also present, requiring the customers to pay through the Matibay Shoe cashier, signifies that their services were not engaged by the customers. Equally important was Matibay Shoe, which gave the Shoeshine boys their daily wage. The third element is satisfied, requiring the Shoeshine boys to be present from store opening until store closing, and to follow company rules on cleanliness and decorum shows that they cannot conduct their own activity anywhere else but inside the store of Matibay Shoe. Hence, their means and methods of accomplishing the desired services for the customers of Matibay Shoe was controlled by it. Lastly, the fourth element is made apparent when Matibay Shoe barred the Shoeshine boys from continuing with their work-related activity inside its establishment. Alternative answer, no. The elements to determine the existence of an employment relationship are the selection and engagement of the employees, B. The payment of wages, C. Employer's power to control the employee's conduct, and the power to dismiss. The first element is absent. The mere issuance of an ID to the boys is not conclusive of the power of selection of Matibay Shoe. They may be given IDs merely as a security measure for the establishment. Furthermore, using the control test, the boys have exclusive power over the means and method by which the shoe shining activity is to be conducted. Kinds of employment. 2016. What limitations, if any, do the law and jurisprudence impose on an employer's right to terminate the services of a probationary employee? The Labor Code in Article 281 provides that the services of an employee who has been engaged in a probationary basis may be terminated for a just cause, as when he fails to qualify as a regular employee in accordance with reasonable standards made known by the employer to the employee at the time of his engagement. If the probationary employee is being terminated for just cause, he must of course be given due process before his termination. Q. During his probationary employment, 8 employees were berated and insulted by their supervisor. In protest, they walked out. The supervisor shouted at them to go home and never to report back to work. Later, the personnel manager required them to explain why they should not be dismissed from employment for abandonment and failure to qualify for the positions applied for. They filed a complaint for legal dismissal against their employer. As a labor arbiter, how will you resolve the case? I will rule in favor of management. First of all, there was no abandonment because there was no intention not to return to work. It was just that the 8 employees were berated and insulted and even told never to report back to work. It was but natural for them to feel demoralized, but there was never an indication to abandon their employment. The probationary workers could, however, be terminated for failing to meet probationary standards. If the reasons for the supervisor's berating and insulting behavior were poor or substandard performance on the part of the workers, their probationary employment could be legally terminated. Mr. X was hired by Y Company on probation for 6 months as general utility worker. On the expiration of the probationary period, Mr. X was informed by Y Company that his work was unsatisfactory and failed to meet the required standard. To give him a chance to improve his performance, Y Company, instead of terminating Mr. X's services, extended, with X written consent, the probation period for another 3 months. This extension notwithstanding, his performance did not improve, on account of which Y Company terminated Mr. X's services at the end of the extended period. Mr. X filed a case for illegal dismissal, contending that he was already regular at the time of his dismissal, pursuant to Article 281 of the Labor Code, the particular portion of which provides an employee who is allowed to work after a probationary period shall be considered a regular employee. Therefore, he could not have been lawfully dismissed for failure to meet company standards as a probationary worker, decide with reason. Mr. X could not argue that because his probationary period was extended beyond 6 months, he was now a regular employee and thus could no longer be terminated, except for just cause or when authorized by law. The fact is that the probationary period of Mr. X was extended beyond 6 months with his consent. It was to give him an opportunity to improve his performance. Thus, it was legal for Y Company to terminate Mr. X for his failure to meet company standard as a probationary worker. The Labor Code provides that probationary employment shall not exceed 6 months, but the Supreme Court has ruled that said probationary period could be extended with the consent of the probationary employee to give him an opportunity to improve his performance. Article 281 Labor Code. Amaya was employed as a staff nurse by St. Francis Hospital, SFH, on July 8, 2014, on a probationary status for 6 months. Her probationary contract required, among others, strict compliance with SFS Code of Discipline. On October 16, 2014, Dr. Ligaya filed a complaint with the SFH Board of Trustees against Amaya for uttering slanderous remarks against the former. Attached to the complaint was a letter of Minda, mother of the patient, who confirmed the following remarks against Dr. Ligaya. Bakit si Dr. Ligaya pa ang napili mong pedya? Ang tanda-tanda na nun makakalimutin. Alam mo ba, kahit wala namang diferensya yung baby, pinapa-isolate niya. The SFH president asked you, being the hospital's counsel, which of these two options is the legal and proper way of terminating Amaya? A. Terminate her for a just cause under Article 228 of the Labor Code, or B. Terminate her for violating her probationary contract. Explain. 2016. I will advise the president of SFH to terminate Amaya for violating her probationary contract. Part and parcel of the standards of her employment is to strictly follow the code of conduct of SFH. The act of defaming Dr. Ligaya is certainly a misdemeanor that is usually not acceptable in any work environment. With such attitude Amaya displayed, she cannot pass the company standard of SFH. I will not suggest the dismissal of Amaya under Article 297. Though she displayed misconduct, the same is not work-related, as spreading a rumor against a doctor does not go into the duties and responsibilities of his staff nurse. Alternative answer. I will advise the president of SFH to terminate Amaya for a just cause under Article 297 of the Labor Code in relation to Article 296. The Labor Code assigns a separate provision, Article 296, and provides a different set of grounds for the dismissal of probationary employees. The law does not preclude the employer from terminating the probationary employment if the employer finds that the probationary employee is not qualified for regular employment, as long as the termination was made for reasons provided under Article 296 of the Labor Code before the expiration of the 6 months probationary period. The employer is well within its right to sever the employer-employee relationship. Pasamba versus NLRC, 2007. Q. Super Comfort Hotel employed a regular pool of excavators who are called or asked to report for duty when the hotel's volume of business is beyond the capacity of the regularly employed waiters to undertake. Pedro has been an excavator for more than 10 years. He is also called upon to work on weekends, on holidays, and when there are big affairs at the hotel. What is Pedro's status as an employee under the Labor Code? Why? Pedro has acquired the status of a regular employee. Pedro was engaged to perform activities which are necessary or desirable in the usual business or trade of the employer. Moreover, Pedro has been excavator for more than 10 years. Under the law, any employee has rendered services at least 1 year of service, whether such service is continuous or broken, shall be considered a regular employee with respect to the activity in which he is employed, and his employment shall continue while such activity exists. Article 280 of the Labor Code. Q. Kitcha Tempo was one of the approximately 500 production operators of High-Tech Semiconductors Incorporated, an export-oriented enterprise whose business depended on orders for computer chips from overseas. She was hired as a contractual employee 4 years ago. Her contracts would be for a duration of 5 months at a time, usually after a month interval. Her rehiring was contingent on her performance for the immediately preceding contract. 6 months after the expiration of her last contract, Kitch went to High-Tech's personnel department to inquire why she was not yet being recalled for another temporary contract. She was told that her performance during her last stint was below average, since there was no union to represent her. Kitch seeks your advice as labor lawyer about her chances of getting her job back. What will your advice? Kitch's below average rating will not matter. She was a regular employee from day one of her services. Her work was evidently usually necessary or desirable to High-Tech's usual business. Under paragraph 1 of Article 280, Kitcha is a regular, not casual, employee. Also, Kitcha obtained permanent regular employment when she was repeatedly rehired by High-Tech. As a permanent regular employee, working for an indefinite period, Kitcha is entitled to the reliefs of reinstatement and fullback wages as mandated in Article 279 of the Labor Code. A below-average rating would matter if Kitchi was made to undergo probationary employment or was a probationary employee under Article 281 of the Code. She was not, obviously. She was a qualified and competent production operator. She would not have been repeatedly rehired if she were not that qualified and competent. I will thus advise her to sue for illegal dismissal, with prayer for regularization in addition to the reliefs of reinstatement and full back wages provided for in Article 279 of the Labor Code. Casual. Q. A carpenter is employed by a private university in Manila. Is the carpenter a regular or casual employee? If the employment of the carpenter is sporadic and brief in nature or occasional, his employment is casual, especially because the work he is performing is not in the usual course of the school's trade or business. However, if the carpenter had rendered services for at least 1 year, whether continuous or broken, he becomes a regular employee by operation of law, with respect to the activity in which he is employed, and his employment shall continue while such activity exists. Article 280 of the Labor Code. Contractual. Q. Lena has been working as a steward with the Miami, USA-based Loyal Cruise Lines for the past 15 years. She was recruited by a local manning agency, Macapagal Shipping, and was made to sign a 10-month employment contract every time she left for Miami. Macapagal Shipping paid for her Lena's round-trip travel expenses from Manila to Miami. Because of a food poisoning incident which happened during her last cruise assignment, Lena was not rehired. Lena claims she has been legally terminated and seeks separation pay. If you were the labor arbiter handling the case, how would you decide? 2014. I will dismiss Lena's complaint. Lena is a contractual employee, and the length of her employment is determined by the contracts she entered into. Here, her employment was terminated at the expiration of the contract. Milares et al. Versus NLRC. Q. After 30 years of service, Beta Company compulsorily retired Albert at age 65, pursuant to the company's retirement plan. Albert was duly paid his full retirement benefit of 1 month pay for every year of service under the plan. Thereafter, out of compassion, the company allowed Albert to continue working and paid him his old monthly salary rate, but without the allowance that he used to enjoy. After 5 years under this arrangement, the company finally severed all employment relations with Albert. He was declared fully retired in a fitting ceremony, but the company did not give him any further retirement benefits. Albert thought this treatment unfair as he had rendered full service at his usual hours in the past 5 years. Thus, he filed a complaint for the allowance that were not paid to him and for retirement benefit for his additional 5 working years, based either on the company's retirement plan or the retirement pay law, whichever is applicable. After Albert's retirement at age 65, should he be considered a regular employee entitled to all his previous salaries and benefits when the company allowed him to continue working? 2013. He would be considered a contractual employee, not a regular employee. His salaries and benefits will be in accordance with the stipulations of the contract he signed with the company. The present case is similar to a case decided by the Supreme Court, Januaria Rivera versus United Laboratories, where the court held that the company in employing a retired employee whose knowledge, experience, and expertise the company recognized as an employee or as a consultant is not an illegality. On the contrary, it is a recognized practice in this country. Q. How is a project worker different from a casual or contractual worker? A project worker is employed for a specific project or undertaking, the completion or termination of which is determined at the time of his engagement. His work need not be incidental to the business of the employer. His employment may exceed 1 year without necessarily making him a regular employee. A casual employee is engaged to perform a job, work, or service which is incidental to the business of the employer. Moreover, the definite period of his employment is made known to him at the time of his engagement. His continued employment after the lapse of 1 year makes him a regular employee. Under the Social Security law, employment that is purely casual and not for the purpose of occupation or business of the employee is not under the coverage of the aforesaid law. A project worker, on the other hand, is a specific term used to designate workers in the construction industry hired to perform a specific undertaking for a fixed period, which is coterminous with a project or phase thereof, determined at the time of the engagement of the employee. Policy Instruction Number 19, Dole. And it is mandatorily required that a termination report be submitted to the nearest public employment office upon the completion of the construction project. A rural land projects versus NLRC. There is no such requirement for an ordinary contractual worker. Q. Diosdado, a carpenter, was hired by Building Industries Corporation, BIC, and assigned to build a small house in Alabang. His contract of employment specifically referred to him as a project employee, although it did not provide any particular date of completion of the project. Is the completion of the house a valid cause for the termination of Diostado's employment? If so, what are the due process requirements that the BIC must satisfy? If not, why not? The completion of the house should be valid cause for termination of Diostado's employment. Although the employment contract may not state a particular date, but if it did specify that the termination of the parties' employment relationship was to be on a day certain, the day when the phase of work would be completed, the employee cannot be considered to have been a regular employee. Filipinos prefabricated building system versus Puente. To satisfy due process requirement under Dole Department Order Number 19 Series of 1993, the employer is required to report to the relevant Dole Regional Office the fact of termination of project employees as a result of the completion of the project or any phase thereof in which one is employed. Q. Martillo and other similarly situated project workers demanded that the increase be extended to them, inasmuch as they should now be considered regular employees and members of the bargaining unit. If you were ABC's legal counsel, How would you respond to this demand? As legal counsel for ABC, I would argue that the employment of Martillo was fixed for a specific project or undertaking, the completion or termination of which has been determined at the time of his engagement. Rendering 14 months of work does not make him a regular employee. When to begin, he was employed for a specific project, which is the construction of a particular 40-story building. The rule on more than 1 year of service making the employment regular applies only to casual employees. Hence, Martillo does not belong to the bargaining unit of regular employees. Q. Design Consultants, Incorporated was engaged by the PNCC to supervise the construction of the South Expressway extension. Design Consultants hired Omar as a driver for 2 years. After his 2-year contract expired, he was extended another contract for 9 months. These contracts were entered into during the various stages and before the completion of the extension project. Omar claims that because of these repeated contracts, he is now a regular employee of Design Consultants. Is he correct? Yes. The principal test for determining whether a particular employee is a project employee or distinguished from a regular employee is whether or not the project employee was assigned to carry out a specific project or undertaking, the duration and scope of which were specified at the time the employee was engaged for the project. In the problem given, there is no showing that Omar was informed that he was to be assigned to a specific project or undertaking. Neither has it been established that he was informed of the duration and scope of such project or undertaking at the time of his engagement. Felix Mining versus NLRC. Moreover, the rehiring of Omar is sufficient evidence of the necessity or the indispensability of his services to the company's business, a rural land project versus NLRC. Hence, Omar is correct in claiming that he is a regular employee of Design Consultants Incorporated. Fixed term. Lucy was one of approximately 500 call center agents at Hamburgis. She was hired as a contractual employee 4 years ago. Her contract would be for a duration of 5 months at a time, usually after 1-month interval. Her rehiring was contingent on her performance for the immediately preceding contract. 6 months after the expiration of her last contract, Lucy went to Hamburg's personnel department to inquire why she was not yet being recalled to work. She was told that her performance during her last contract was below average. Lucy seeks your legal advice about her chances of getting her job back. What will your advice be? Lucy cannot get back her job. She is a fixed-term employee, and as such, her employment terminates upon the expiration of her contract. Roel Industrial Corporation versus Court of Appeals. 2014, Bar. Subcontracting versus labor-only contracting. 2016. 2015, 2012. What is a labor-only contract? Labor-only contract is a contract between an employer and a person who supplies workers to such employer, where the person supplying workers does not have substantial capital or investment in the form of tools, equipment, machineries, work premises, among others, and the workers recruited and placed by such person are performing activities which are directly related to the principal business of such employer. Article 106 Labor Code. Distinguish the liabilities of an employer who engages the services of a bona fide independent contractor from one who engages a labor-only contractor. 2012. A person who engages the services of a bona fide independent contractor for the performance of any work, task, job, or project is the indirect employer of the employees who have been hired by the independent contractor to perform said work, task, job, or project. In the event that the independent contractor fails to pay the wages of his employees, an indirect employer, in the same manner and extent that he is liable to employees directly, is jointly and severally liable with the independent contractor to the employees of the latter to the extent of the work performed under the contract. As for the person who engages the services of a labor-only contractor, the latter is considered merely as an agent of the former, who shall be responsible to the workers hired by the labor-only contractor in the same manner and extent as if he directly employed such workers. Starcraft is a lantern maker based in Pampanga. It supplies Christmas lanterns to stores in Luzon, Metro Manila, and parts of Visayas, with the months of August and to November being the busiest months. Its factory employs a workforce of 2,000 workers who make different lanterns daily for the whole year. Because of increased demand, Starcraft entered into a contractual arrangement with People Plus, a service contractor, to supply the former with 100 workers for only 4 months, August to November, at a rate different from what they pay their regular employees. The contract with People Plus stipulates that all equipment and raw materials will be supplied by Starcraft, with the express condition that the workers cannot take any of the design home and must complete their tasks within the premises of Starcraft. Is there an employer-employee relationship between the Starcraft and the 100 workers from People Plus? Yes. People Plus is a labor-only contractor because it is not substantially capitalized. Neither does it carry on an independent business in which it uses its own investment in the form of tools, equipment, machineries, or work premises. Hence, it is just an agent or recruiter of workers who perform work directly related to the trade of Starcraft. Since both the essential element and the conforming elements of labor-only contracting are present, Starcraft becomes the employer of the supplied worker. As principal, Starcraft will always be an employer in relation to the workers supplied by its contractor. Its status as employer is either direct or indirect depending on whether the contractor is legitimate or not. Thus, even if People Plus were a legitimate job contractor, still, Starcraft will be treated as a statutory employer for purposes of paying the workers unpaid wages and benefits. Q. Pablo was a farm hand in a plantation owned by ABC and Company, working approximately 6 days a week for a good 15 years. Upon Pablo's death, his widow filed a claim for burial grant and pension benefits with the Social Security system. The claim was denied on the ground that Pablo had not been a registered member employee. Pablo's widow filed a petition before the SSS asking that ABC and Company be directed to pay the premium contribution of Pablo and that his name be reported to SSS coverage. ABC Company countered that Pablo was hired to plow, harrow, and burrow using his own carabao and other implements and following his own schedule of work hours without any supervision from the company. If proven, would this factual setting advanced by ABC and Company be a valid defense against the petition? ABC and Company has a valid defense. Pablo should be an employee of ABC and Company to be under the compulsory coverage of the SSS. To be an employee, Pablo should be under the control of ABC and Company as regards his employment. But the facts show that he was not under the control of ABC and Company as regards his employment. Among others, he had his own schedule of work hours without any supervision from the company. Thus, he is an independent contractor and not an employee. An independent contractor is not under the compulsory coverage of the SSS. He may be covered as a self-employed person, but then as such, ABC and Company has no legal obligation to report Pablo for coverage under the SSS because ABC Company is not Pablo's employer.